Thank you, Mr. Chair. I was standing beside Rep. Co-Chair and urging a yes on this amendment. The underlying bill does consider the court behavior here in this conversation, and we had this conversation in Early Learning Human Services, and frankly, what this bill seeks to solve and what it puts in place is just more steps between what we know is a danger and a child being safe. And I guess the big question is, does this conversation belong as part of that conversation? I think it absolutely does. And that's why I'm in support of this. We know that there's a problem, Mr. Chair. We know that without action taken this legislative session, more children are going to die. And when you read those unexpected fatality reports, you read one and it's a tragedy. You read another one and it hurts you to your core. You read one and one and one. At some point, everything starts to rhyme, and you say, "Why is it rhyme? Why can't we fix this?" And you go to try to fix this, and every opportunity to fix this gets pulled away, and then we run into a situation where we have this ambiguous thing that we're going to ask a court to interpret: imminent physical harm. But that's the same standard that has failed us for these last several years. It's failed us since at least 2023, if not before, when it was implemented as a silent standard before 2023. It has failed us for years, and this amendment just gives the court a little bit more latitude to evaluate the totality of the danger that these children face before they die, before they end up in another unexpected fatality report. Mr. Chair, we're not talking one or two, we're talking hundreds at this point. Hundreds that we know about. Hundreds that have reached the point of having a fatality report, and we know that without a fix this legislative session, whether it's through this bill or some other bill that doesn't exist, there'll be 50 more. This is a good amendment. It gives a court some latitude to evaluate whether or not there is something beyond imminent physical harm. What does imminent physical harm mean? If we sat here and took a test, the 30 of us up here, I don't know that any of us would pass that test. That's what social workers are facing in the field right now. When you speak with social workers about what imminent physical risk looks like, they'll show you pages long of notes saying that they've tried to pull kids out of these situations. They've worked with everyone that they can work with to get kids out of these situations, and that they've run against the same barriers we've run against. They've run against an institutionalized vision of keeping families together that is not working, very clearly not working. This is a good amendment that moves the needle. It probably doesn't solve the whole situation, but if we're going to ask shelter care hearings and we're going to ask judges and courts to go through a process that doesn't even mandate parents follow through with the orders, then this is something to give them. You know, in committee, I asked this directly of DCYF, what happens if in a court the judge says you're going to have to do this? And they said, well, because DCYF ultimately gets the ultimate response here. The court can't mandate anything. They can say you have to do it, the parent won't do it, and then what happens? It's right back in DCYF's hands. You end where you started. Nothing really changes ultimately with 2660, even if it passes. But this at least enshrines at least a little bit into law, some more latitude for the court. It's a good amendment. Vote yes.